everybody. Before we begin, I would just like to mark this historic occasion of the Supreme Court sitting in Northern Ireland by saying how delighted I and my fellow justices are to be in Belfast. This is only the second time that the Supreme Court has sat outside London, and we are very much looking forward to our time here this week. Sitting outside London enables us to emphasise the role of the court in serving the people and communities of every part of the United Kingdom. We're very grateful to the support and welcome of the Lord Chief Justice of Northern Ireland, to the Bar Council for allowing us to use these premises, and to all those who provided assistance to allow these hearings to take place. We're particularly pleased to see those of you who've taken the trouble to come and watch us in these proceedings, since that's much of the point of our coming outside London, to give that opportunity to other people. We'll be hearing two cases during our time here, both of them in fact appeals from the Court of Appeal of Northern Ireland, one of them involving very complicated points of the Northern Ireland Constitution, and we shall also be giving judgment in a Northern Irish case that we have heard in London. So we are attempting to behave as closely as possible to the way in which we behave in our courtroom in London. And those of you who have experience of that, I hope, will find that nothing is too unfamiliar to you. And thank you all for participating in this historic occasion.
Hearing in the matter of an application by Siobhan McLaughlin for the judicial review.
Yes.
My ladies and my lords, I appear on behalf of Ms McLaughlin, the appellant in this case, together with Ms Laura McMahon, Dr Tony McLean, Mr Tony Lunny and Ms Laura Curran appear on behalf of the respondent to the appeal.
Mr Donald Lunny, I think.
Donald Lunny, I beg your pardon. Ms Helen Mounfield and Mr Royston appear on behalf of the interveners. My ladies and my lords, the facts of this case are clearly set out in the statement of facts and issues and in the statements of case prepared by each of the parties. In summary, the appellant cohabited with her partner, John Adams, who was himself a widower for some 23 years up until his untimely death on the 28th of January 2014. They did not marry, honouring a promise made by John to his own predeceased wife that he would not remarry. And
that's of course very commendable, but it's not strictly relevant.
No, my lady, I understand that, but I think I should just set out the background facts. And the appellant and John Adams went on to have 4 children. In the statement of facts and issues, in particular, I don't need to open this to you, but paragraph 3 of the core bundle, page 169, it is set out that during their cohabiting relationship, they were assessed as a couple by the state in relation to the receipt of various state benefits. For example, pension credit, housing benefit, and the applicant claimed and was paid carer's allowance for looking after John during the period of his terminal illness. And one of the points indeed made by the National Children's Bureau in its intervention is that for benefits purposes, our social security system recognises couples who cohabit for the purpose of calculating tax credits, pension credits, and income-based benefits such as employment support allowance, ESA, and income support. But yet the status of cohabiting partners is insufficient to qualify for bereavement benefit or indeed widowed parents allowance, which is the issue in this case, even though the surviving partner, such as this appellant, had for many years cohabited and been treated by the state for other social security benefits and credits as being part of a recognised couple.
But is there not a difference between the benefits to which you have referred and this benefit?
Well, there are several differences.
Well, the benefits that the benefit that we're concerned with is a contributory benefit.
Yes, my lady. Yes.
What used to be called a national insurance
yes,
benefit.
Yes.
Whereas, am I right in thinking that the other benefits to which you've referred are all income-related benefits and not contribution-related benefits.
I think that is right, my lady. I'll just check that in detail, but I think that you are right in relation to all of
Well,
those.
we
Yes,
shall need to consider whether that is a material difference.
yes, my lady. Upon John's death on the 20th of January, the appellant then applied for bereavement payment and widowed parents' allowance, and as the court knows from the documents in this case, the application was rejected on the grounds that she was not married at the time of the deceased's death. And that, of course, had an impact upon her. The bereavement benefit, a lump sum of £2,000, was unavailable to her. That does not form part of this appeal. It also disqualified her, as we know, from the widowed parents' allowance. She appealed in due course to the Social Security Appeal Tribunal. It made its decision on the 18th of April 2014, and it rejected the appeal on the grounds, again, that the appellant could not prove that she was married at the time of death. The decision was then the subject of a judicial review, which came before Lord Justice Tracy, Mr. Justice Tracy as he then was. And Mr. Justice Tracy allowed the judicial review in part, that part being in relation to the appellant's claim for widowed parents' allowance under Section 39A(1) of the 1992 Act. We have set out in our statement of case, my lady, I don't propose to review it in detail, but it is in our written case, the judgments of both at first instance and at the Court of Appeal and their reasoning. But the essence of Mr. Justice Tracy's reasoning is to be found at paragraphs 68 to 73 of his judgment, and in summary, dealing with the twin issues of comparability and justification, he found at paragraph 68 that the appellant's position was analogous to that of the surviving spouse or civil partner for the purposes of the widowed parents' allowance.
You are going to give us the electronic page references?
Yes, my lady.
Anything you want us actually
I
to
shall.
read?
I certainly shall, my lady. And I should have done that. Unfortunately, I have not marked that particular page. I'll come back to it, my lady. But I have done in the remainder of my arguments. At paragraph 71, he said that the difference in treatment could not be justified.
462.
Thank you, my lord. Thank you, my lord. He described the restriction as being inimical to children. He considered that the focus should be on the survivor's nexus with the child of the deceased. And he said, were it otherwise, it might be said that the birth status of the children would result in them being treated less favourably. And accordingly, at paragraph 73, he then found that there was a restriction. The restriction was a violation of Article 8, taken with Article 14, in that it discriminated unjustifiably against the appellant on the grounds of her marital status. He made no ruling as to A1P1. The department then appealed to the Court of Appeal. The judgment was given by Lord Justice Weatherup on behalf of the court. The judgment is to be found at page 65 of the Core Volume 1. Again, we've summarised the content and the reasoning of that judgment in Chapter 8 of our statement of case between paragraphs 45 and 71. The court disagreed with Mr. Justice Tracy's findings. They said that the responsibilities of survivors were not the determining factors in the approach of the government. They said that the statutory scheme was not based on a nexus between the deceased and the children. It's at paragraph 60, page 84, my lord.
Well, you're not giving us the electronic numbers.
My lord, I thought I... My lord,
You're not. It starts at 413 or 412.
64, paragraph 64 is at 431.
My lords, I do apologise. I had checked that the numbers appearing on my page were the electronic numbers, and I was told that they were. And if they're not, then I do apologise.
You're going to need some help from your junior.
Well, my lords, I do apologise that I had checked it, and I've been misled, but I'll do the best that I can, my lady.
You wouldn't be the first.
I do apologise.
And my lord and I rely on the electronic bundle.
I do understand that, and I've had this before, and which is why I did check it. Very well.
Anyway, there's always something about the electronic bundle at the beginning of every case.
Yes.
So this should not be any exception.
I know, but it's unfortunate. Very well, my lady. I'll continue as best I can. The court held at paragraph 61 that the true reason for the different treatment of the cohabitees was based on a marital status, which was, of course, a non-suspect ground. The leave was then sought by the appellant before this court and granted on the 26th of May 2017, and the issue before the court is whether the eligibility requirement of a marriage or civil partnership under section 39A1 amounts to unlawful discrimination against partners living in a cohabiting relationship and or the children of partners living in such a relationship contrary to Article 14 in conjunction with Article 8 or A1P1.
Well, by definition, there have to be what one might call qualifying children, do they not?
Yes.
Because it's a parent's allowance.
Yes, ma'am. And the qualifying children are set out at section 39 A3 of the Act. If I could ask you just to go to Core Volume 1, or sorry, Authorities Volume 1, and just open the Act to you. If the court would go to, and I do apologise for this, my lady and my lords, I was going to ask you to go to page 1118, which is of the hard copies.
Oh, that's all right.
And
You're all right with the authorities?
very well, thank you, my ladies.
The core bundle.
That's fine. It's the core bundle is the problem then. Thank you. So if we go to 1118, section 39A, you would see section 1, subsection 1 says that this section applies where a person whose spouse dies on or after the appointed day is under pensionable age at the time of the spouse's death, or B, a man whose wife died before the appointed day, has not remarried before that day, and secondly is under pensionable age on that day. And if we go then to you talked about the qualifying children, if you go to subsection 3, a child falls within this subsection if one of the conditions specified in section 81.2 below is for the time being satisfied with respect to the child, and the child is either A, a son or daughter of the surviving spouse and the deceased spouse, or B, a child in respect of whom the deceased spouse was immediately before his or her death entitled to child benefit, or C, if the surviving spouse and the deceased spouse were residing together immediately before his or her death, a child in respect of whom the surviving child was then entitled to child benefit. So, in essence, there is a familial relationship, son or daughter under subsection A, and then B and C deal with children within the household in respect of whom child benefit is being claimed. And child benefit is payable up to the age of 16, and if they are in qualifying education, it's payable up to the age of 20. So in seeking to address the issues before this court, what I respectfully propose to do is to use the template adopted by Lady Hale in Gaydon and Godin Mendoza to ask the 5 questions. First of all, do the facts fall within the ambit of one or more of the Convention rights? Secondly, was there a difference in treatment? Thirdly, were those others with whom we seek to compare ourselves in an analogous position? Fourthly, the issue of justification. Does the measure have a legitimate aim and bear a reasonable relationship of proportionality to the aim? And then fifthly, is the difference in treatment based on one or more of the prescribed grounds, that is, those prescribed grounds within Article 14. So if I might, my lords and my ladies, go to the first question, which is the issue of ambit of one or more of the Convention rights. In answering this question, the parties agree that Article 14 is triggered. This is hardly surprising, given that the European Court in Shackle and in Willis, which are respectively at Volume 1, tabs 4 and tab 6. That's pages 1138 and 1162. They say that this very statutory provision falls within the ambit of A1P1. Unless the court needs submissions or further oral submissions on that issue, I don't propose to say much more on the A1P1 point.
Well, it's not contentious, is it?
It's not, my lady, and I didn't propose to deal with it by way of oral
Article
submission.
8 is contentious,
It is,
but A1P1
yes,
is not.
So Inns and Austria, which is at tab 3 of Volume 1, at paragraph 36 of that judgment, I'll not open it to you, my ladies, because it's well known, but tells us that Article 14 is triggered as long as the facts of the case fall within at least one of the substantive provisions of the Convention and its protocols. And in subsequent European cases, such as Shackle and indeed Willis, this observation has been interpreted as meaning that as soon as it is determined that the facts fall within the ambit of one of the substantive Convention and protocol rights, it is not necessary to go any further. However, our submission that we say that in order to establish if there is a difference in treatment in respect of a convention right between the complainant and others put forward for comparison, the second question in Gaydon, if you like, we submit that it can be unsatisfactory not to go in on any further. And where it is alleged that the measure falls within the ambit of more than one convention right, one really has to come to a conclusion as to whether or not that is correct before one can then go on to answer the second and indeed all of the other questions in Gaydon, in the Gaydon checklist. And this has been the approach adopted on several occasions, indeed on many occasions, by our domestic courts where a measure falls arguably within more than one convention right. And I cite by way of example the case of M, which is at Volume 4, tab 32. Again, I don't need to open the case to you, my lords and my ladies, but that was a case where Article 8 and Article A1P1 both came into play in relation to the impact of the child support scheme. In the present case, we say that this is important. The respondent concedes that the measure falls within the ambit of A1P1. We say that the measure also falls within the ambit of Article 8. And even though the European Court of Human Rights may consider it unnecessary to examine the ambit of other articles, in our submission it is instructive to do so, and that this course should commend itself to this court in this case.
But what difference does it make?
Well, my lords and ladies, it informs us certainly as regards to the differences, the material differences. It also informs us on the whole issue of justification. And in our respectful submission, well, I think my primary submission is that it assists in answering all of the other questions in Gaydon 2, 3, 4 and 5, but principally 2 and 4.
Does it make any difference to the test?
The
A1P1, manifestly without reasonable...
It may do. I do want to make some submissions on that, my lady, because and I know that this court has struggled with that issue over many cases, but in our respectful submission, yes. In answer to your question, the answer is yes. We say it does. We say that the appropriate test in this case is very weighty considerations, and I will come to that in due course, my lady, if you would just allow me. So, and that's within the context of justification. So what I propose is to ask you to consider some short submissions on the issue of the ambit of Article 8. Article 8, of course, imposes no positive obligation upon the state to make any financial provision for anyone to cope with bereavement. The right to respect for family life embraces the concepts of the rights of survivors in relation to deceased loved ones. In our statement of case, although we accept at paragraph 237 that we cannot point to any express European Court authority dealing precisely with the right to grieve or to experience or to cope with bereavement or to be assisted in coping with bereavement. There are two cases, Panulo and France and Girard and France, where the court did acknowledge that rights of burial were protected by Article 8 and can be infringed by delay, for example, in the return of body parts. But where, however, the state elects, as here, to provide a measure that does fall, we say, within the ambit of Article 8, we say it must provide the measure without discrimination, in compliance with Article 14. The well-known case of Petrovich and Austria, which is at volume 6, tab 52, page 2909, is, in our respectful submission, a clear example of this. Just some observations about Petrovich that the court may want to take note of. First of all, the case was heard and adjudicated upon by the Chamber in February 1998, which was 2 years prior to Shackle. Shackle was decided by an entirely differently constituted chamber to that in Petrovich. The facts in Petrovich, it's at page 2909, my lady, if I just open tab 52. Now, the facts of the case, briefly stated in Petrovich, are that Petrovich's wife gave birth. She elected to continue working, while Petrovich, who was a part-time worker, took parental leave. He sought to claim parental leave allowance from the Austrian state. So it was a case involving an allowance. This was, to foreshadow Lady Hill's intervention, a non-contributory allowance. It was not dependent upon the spouse having paid into a national insurance fund. Petrovich was turned down on the grounds that this allowance was available only to mothers. And when the case eventually reached the European Court, he claimed that his entitlement to the allowance constituted discrimination, contrary to Article 14, taken together with Article 8. So it was an Article 8 case, not an A1P1 case.
Was there no mention of A1P1?
No. The court considered the applicability of Article 14 taken together with Article 8, commencing at paragraph 22. And if I might, my ladies and my lord, just refer you to page 2915. So this is the dealing with the applicability of Article 14 taken together with Article 8. Paragraph 22 is a well-trodden paragraph that one sees in many European judgments dealing with the effect of Article 14. Paragraph 23, the court noted that the applicant's argument that any financial assistance enabling parents to stop working in order to look after their children affected family life and therefore came within the scope of Article 8 of the Convention. At paragraph 24, the court noted the government's argument that parental leave allowance did not come in with the scope of Article 8, since Article 8 did not contain any general obligation to provide financial assistance to parents so that one of them could stay at home to look after their children, and secondly, that parental leave allowance was a matter of welfare policy, which was not to be included within the concept of family life. At paragraph 26, the court accepted there was no breach of Article 8. Of course, a breach is not the test for Article 14 purposes. And at paragraph 27, the court noted that the allowance was paid by the state and was intended to promote family life, and necessarily affected the way in which family life was organised, as it enabled one of the parents to stay at home to look after the children. At paragraph 28, the court reiterated what it had said on many occasions, that Article 14 comes into play whenever the subject matter of the disadvantage constituted one of the modalities of the exercise of a right guaranteed, or the measures complained of are linked to the exercise of a right guaranteed. And at paragraph 29 then, the court said that by granting parental leave allowance states, or parental leave allowance, states are able to demonstrate their respect for family life within the meaning of Article 8 of the Convention, and that it therefore followed that the payment of that allowance came within the scope of that provision, and accordingly Article 8, when read with Article 14, when read with Article 8, was applicable. Now, there are some important similarities and some significant differences between Petrovich and Shackle. Shackle, of course, if I might just open that to you at this stage, it's in the Authorities, Volume 1, at tab 4. Page 1138, my lord. 1138.
Thank you.
So Shackle, as we know, the facts of that case dealt in particular with a number of benefits, but including what was then widowed mother's allowance, not widowed parents' allowance. And the factual matrix of that case is very similar to the factual matrix that we have here, if not virtually identical. Reading from the circumstances of the case at 1139, the applicant commenced a long-term relationship with Ian Green in September 1978. They never married, but lived together until Ian Green died in September 1995 from an accident at work, and the couple had 3 children. Mr. Green was a self-employed builder. He paid full social security and national insurance contributions, and his contribution record was such that had he been married to the applicant, as in our case, she would have been entitled to social security benefits as his widow on his death. And she made an application for the various menu of benefits that would have been available to a married woman. And the complaint fell for discussion. In that case, the application was brought. As Ms. Mountfield has said in her intervention, the applicant appears to have been unrepresented in this case. And certainly the reasoning is pithy, to say the least, by this court. But Article 14 was looked at vis-à-vis Article 8 and Article 1.
According to the first paragraph, she was represented by a welfare rights worker.
Yes.
Or was it not a lawyer?
Welfare rights, yes, not a lawyer, yes. Thank you, my lord. But in any event, Article 8 and Article 1 of the first protocol were raised. The court continued at the bottom of 1141 into the top of 1142. Says the applicant argued that her entitlement to widow's benefit is a pecuniary right for the purposes of A1P1. The court recalls that in the above-mentioned case, which was Gegus's, the applicant's entitlement to social benefits was linked to the payment of contributions, and in the present case, Mr. Green had paid those contributions, and they found that it fell within the ambit of A1P1, and there was no need to consider in those circumstances Article 8. So there are factual differences between Petrovich and Shackle. In Petrovich, there was no argument advanced on behalf of the applicant that the payment of parental leave fell within the ambit of A1P1. One can only assume, as you have said, my lady, that that was because of the absence of any requirement to pay into a fund. There was a perception on the part of Petrovich's lawyers that no pecuniary right was created, as was the rationale behind the court's decision in Shackle.
Well, that was the perception in those days.
Yes, madam. Yes. And
times moved on.
And as you've said, we have moved on. But it's respectfully, what we say is that the reasoning in Petrovich is transferable across to the facts of this case. And we say that Petrovich is strong authority for the proposition that the introduction of a Section 39A measure being a measure constituting one of the modalities of the exercise of a right guaranteed or being linked to the exercise of a right guaranteed is a measure falling within Article 8. Petrovich has long been cited in our domestic authorities on this issue, and some of the relevant cases are cited in 2 or more recent Court of Appeal cases, to which I have made reference in our statement of case, and if I might briefly open those to you as well, my ladies and my lord, before moving on. The first is Steinfeld, which is the Court of Appeal case, and I know that this case will fall for consideration by you in due course. We've made some written submissions about this case at paragraph 76 to 79 of our case. The case itself is to be found at volume 5, tab 47, page 2755, my lords and my ladies. Very briefly on the facts of that case, not quite on point. The claimants, being an opposite-sex couple, issued proceedings for judicial review of the continuing decision of the Secretary of State not to put forward changes to the Civil Partnership Act of 2004 to enable opposite-sex couples to enter into civil partnerships. They claimed that the bar on opposite-sex couples entering into a civil partnership by virtue of Section 3 of the 2004 Act was incompatible with Article 14 when read with Article 8. And Section 3 provides that two people are not eligible to register civil partners to each other if they are not of the same sex. So the question that arose was what were the particular features of a case when it falls within the ambit of Article 8. If I might, my ladies and my lords, just ask you to go to the judgment of Lady Justice Arden, and in particular to paragraphs 25. I can go through this very briefly, my lords and my ladies. Paragraph 25 is when Lady Justice Arden deals with the issue of the bar, in that case, being within the ambit of Article 8.
The MS page.
MS page, sorry, I beg your pardon, my lord. It's 2763. It's at the bottom of the page, my lord. So, at paragraph 25, albeit that this is in the context, of course, of relationships, slightly different to this case, Lady Justice Arden said that under Strasbourg law, case law, couples in a stable relationship enjoy family life. States have a positive obligation to ensure respect for family life. At paragraph 28, page 2764, my lords, she observed that not only do cohabiting same-sex couples enjoy family life, but so too must unmarried opposite-sex couples. At paragraphs 66 to 68, page 2775, she rejected the government's argument that an adverse impact had to be established in order for a case to fall within the ambit of Article 8. Now, in this case, we say that there is an adverse impact. Quite clearly, Ms McLaughlin is completely excluded. But in terms of the discussion as to how a case can fall within the ambit of Article 8, and I dare say this is something that this court will probably have to grapple with whenever Steinfeld comes before you, but that was her interpretation of European case law at that time. And at paragraph 70...
Are you aware, I'm afraid I should be aware, but I'm not aware, whether there's a cross appeal in Steinfeld?
I am not aware. I just simply saw in the listing that the case has been appealed and you've granted leave. I'm not sure about the position about
we have given permission, obviously, to the couple to appeal.
Yes.
But I cannot recall whether we've given permission to the government to cross appeal on the ambit point.
I'm not sure. I'm not sure, my lady, and you're quite right to raise it. I know that the court did grant leave on the 8th of August 2017, but that was only for leave to appeal. The
Oh, it's coming up later this term, very soon.
So at paragraph 74, she concluded that the claimants had established that their claim fell within the ambit of Article 8, and paragraph 74 is at page 2776. Lord Justice Beatson also considered the issue of the ambit of Article 8 from paragraph 139 onwards, and that is at page 2792. At paragraph 141, my lords and my ladies, also on page 2792, he too recognised that even absent a legal status, stable and committed same-sex relationships amount to family life. He said that in light of this, it must in principle follow that stable and committed different-sex relationships amount to family life, whether or not the couple have married. He said that it must in principle follow that the disadvantage such couples face when compared with same-sex couples falls within the ambit of family life within Article 8. And we say that drawing on that conclusion, it must follow that the disadvantage that unmarried opposite-sex couples face when compared with married opposite-sex couples or civil partners must also fall within the ambit of family life of Article 8. If I might ask the court to note page 2794, paragraph 146, Lord Justice Beatson cited Pajic and Croatia, where the Chamber had held that a same-sex couple who had been in a relationship for 2 years but who did not cohabit were in a relationship within the ambit of Article 8 for the purposes of Article 14 by reason of the existence of their relationship alone. At paragraph 148, also at page 2794, he concluded that no adverse impact needed to be shown to fall within the ambit of Article 8. And at paragraph 149, then drawing from the judgments of Lord Nichols in the majority and Lady Hale's dissenting judgment in M, Lord Justice Beatson remarked that both considered that if the state chose to legislate in support of or to promote family life, that measures fall within the ambit of Article 8. So we respectfully submit that Steinfeld is an important authority, that the consideration of the ambit of Article 8 is of assistance to this court, and we respectfully rely upon it. The final case that I invite you to look at on this issue is the case of Jacqueline Smith against Lancashire Teaching Hospitals. It's again at volume 5, tab 48, so it's the next hard copy judgment in the same volume, and it's at page 2802. 2802 I have, you have 2802, my lords and my ladies?
Yes.
Yes, thank you. And we refer to this case between paragraphs 80 and 85 of our statement of case.
I suppose we should just note, before leaving Steinfeld, that Lord Justice Briggs agreed with Lady Justice Arden and Lord Justice Beatson on
that issue.
On that issue.
Yes. I don't think he really had much of substance to say about it other than the fact that he agreed.
He had nothing to say about it other than that he agreed. But
yes. There's no cross appeal? Yes. Miss Mindfield tells me there's no cross appeal.
no, I didn't think there was, but not yet, anyway.
Might be after this case.
Well, it's due to start on the 14th of May, I see.
Never too late, my lord. The issue that fell for consideration in Smith does touch on the principles in this case, was whether a measure, in that case it was Section 1A of the Fatal Accidents Act of 1976. We have the equivalent provision in our 1977 order. which makes provision for the payment of bereavement damages. That is a one-off payment now of £12,980 from a tortfeasor, was to be interpreted as extending to a person who was living with but not married to a person now deceased in the same household for at least 2 years prior to the death of that person. So this was not a case involving children. This was simply a cohabiting couple. The presence or otherwise of children was irrelevant to the issues in this case. And in that case, as in this case, the legislature had imposed a condition for eligibility. The relevant legislation is set out at paragraph 9 of the judgment, which is at page 2810. The judgment is by the Master of the Rolls.
So was the position this, that you could get dependency damages
Yes,
after 2 years cohabitation, but you couldn't get bereavement damages?
that's exactly right.
Yeah.
Yes. And section 1A at 2810, as you can see, sets out 1A1, an action under this Act may consist of or include a claim for damages for bereavement. And 2, a claim for damages for bereavement shall only be for the benefit, A, of the wife or husband or civil partner of the deceased. So the claimant, being the surviving partner, contended that the exclusion of those like her who were in a long-standing, loving and stable relationship with her partner but who were unmarried was discriminatory when read with Article 8. And the Court of Appeal, following Steinfeld, agreed. The Master of the Rolls dealt with the ambit test, commencing at paragraph 41. It's page 2817. And between paragraphs 41 and 54, he reviewed all of the relevant authorities, including Petrovich, and Steinfeld, before summarising the legal position at paragraph 55. And we say that this is a particularly apt summary of the legal position, which we respectfully encourage this court to adopt. He said, the legal position, paragraph 55 is at page 2820. The legal position may therefore be summarised as follows in a case where, as here, the claim is that there has been an infringement of Article 14 in conjunction with Article 8. The claim is capable of falling within Article 14 even though there has been no infringement of Article 8. If the state has brought into existence a positive measure which, even though not required by Article 8, is a modality of the exercise of the rights guaranteed by Article 8, the state will be in breach of Article 14 if the measure has more than a tenuous connection with the core values protected by Article 8 and is discriminatory and not justified. And the final sentence we say is particularly important. It is not necessary that the measure has any adverse impact on the complainant in a positive modality case, other than the fact that the complainant is not entitled to the benefit of the positive measure in question. And we say that's really an articulation of Miss McLaughlin's position. If I might, my lords and my lady, just refer you also to paragraph 72, which is at page 2822. In response to submissions made on behalf of the Secretary of State, which were summarised at paragraph 69, that the award of bereavement damages is a fixed sum payable only after death, that is to say, once family relationships have come to an end, and accordingly could not be said in any meaningful way to promote family life. Sir Terence said, and again we rely upon this paragraph, reading down from the second sentence of the paragraph, he says, it is apparent from the very fact that bereavement damages are limited in a section 1A, 2A, to the spouse or civil partner of the deceased, that bereavement damages are specifically intended to reflect the grief that ordinarily flows from the intimacy which is usually an inherent part of the relationship between husband and wife and civil partners. It inevitably flows that the scheme for bereavement damages is probably regarded as a positive measure or modality by which the state has shown respect for family life, a core value of Article 8. And we say in our respectful submission that is a clear articulation of any allowance which deals with the concept of bereavement. And what we do also say is that in many ways the respondent has almost accepted this by its own acknowledgement at paragraph 85, which is in the and I hesitate to refer you to the page as we're going back to the core volume 1. In the respondent statement of case at paragraph 85, just call it up.
I think you'll find.
Try and keep this to a bare minimum.
I think you'll find that that's at 321.
321. Thank you very much, Melody.
Is it? Yes.
On my memory stick numbering, it's 321.
That's right.
Oh,
Just
well, there we are.
So the copies of the case in this form have got correct pagination.
Yes, well, thank you. Then we are on track until we fall off track at some later stage. But in the last sentence of paragraph 85 of the respondent's statement of case, they do say WPA, widowed parents, is a benefit based upon a deceased's national insurance contributions that provides income to persons connected to the deceased who, because of their responsibility for one or more children, are considered to have a particular financial need. And while that is correct, it's also an acknowledgement that there is, it's representing one of the core values being that of family life within Article 8. So, we say, in conclusion, in relation to widowed parents' allowance, that it is, of course, it's payable until the children no longer qualify for child benefits. So it envisages young children.
well, you'd say it's a stronger case than Steinfeld, wouldn't
Yes,
you?
absolutely. The payment is not calculated by reference to any dependency. The measure has been introduced, we say, in obvious recognition of 3 factors. We've itemised those in paragraph 87 of our statement of case. The effect of bereavement, emotional and financial, upon the family unit. And this includes the surviving spouse and civil partner and the children. It reflects the positive obligation on the part of the state to provide some financial support to those in the most acute period of bereavement following the loss of a parent, whose role within the family unit is to make provision, whether by income or by services, to the children and to the surviving parent and spouse. And the scheme, of course, is self-evidently contributory, not by reference to the beneficiary's contributions, but by reference to those who have paid into the contributing fund. And in this way, the state recognises, does it not, that the family unit has lost a parent or a spouse who was providing financial support to that spouse or parent in the discharge of his or her role within the family unit, to parent and also to the children, of course, if one looks at it from the other side of the coin, the children who obtain the benefit of the parenting that's funded by the additional money.
You said for the most acute period, but am I not right that the WPA, which has now been replaced, was available for a much longer period than its replacement?
It is. Yes, exactly, my lord. Now, and in many ways, the new benefit even accentuates that point, because it is clearly in the most acute period. But bereavement, of course, endures bereavement endures forever. But
yes, but potentially WPA could be available for up to 20 years, was it?
Well, certainly up until the age of 20 for,
yes.
for the time period that the child...
If it was a newborn child?
Yes, if it's a newborn child who goes through to the educational route, and child benefit will be payable until the age of 20. So you are quite right.
Thank you.
So in our respectful submission, what we say, to go back to Lady Hale's question, is that if the court concludes that this measure does fall within the ambit of Article 8, as we say it does, then it goes to inform all of the other answers under the Gaydon test. So that's all I propose to say about the issue of ambit, my lords and my ladies, unless there's any further question. The second question then, under the Gaydon framework, is, was there a difference in treatment in respect of that right, and for that right I suppose we should read those rights, between the complainant and others put forward for comparison? This is an issue of fact, is it not? In the context of a positive measure being introduced, and in light of what the Master of the Rules has observed in the Smith case in paragraph 55, it is probably answered very clearly when he observed that it was not necessary that the measure had any adverse impact upon the complainant in a positive modality case, other than the fact that the complainant is not entitled to the benefit of the positive measure in question. And in the present case, spouses and civil partners and their children avail of the benefit. Unmarried partners and their children cannot. And we say that this constitutes a difference in treatment in respect of the ambit of the rights, both under Article 8 and Article P1. So, in our respectful submission, the answer to the second question in Gaydon is that there is a difference. The third question then is to deal with the question of comparability. Were those others in an analogous position? As has been said on many occasions, in considering the issue of discrimination, the European Court has tended to gloss over the comparability issue and to address issues of comparability within the context of justification. However, it has become an issue in this case because there is authority to which the respondent can point, by which the European Court, almost 20 years ago, declared that for the purpose of this legislation, a spouse and an unmarried mother were not to be viewed as analogous. And that case is, of course, Shackle. So we have to accept that Shackle presents a problem that we have to overcome. Now, we have set out in our statement of case why Shackle is an unsatisfactory authority. It's certainly not, we respectfully submit, as Dr. McLaughlin would contend, from a clear and consistent line of authority, as far as widowed parents' allowance or widowed mother's allowance is concerned. The judgment has other limitations. It's a decision on admissibility, it's a majority decision.
Well, how should we look upon an admissibility decision? Should we regard that as strengthening the fact that they're not comparable, or should we regard it as, on the whole, a weaker form of authority?
I think that perhaps the best way to describe it is to look at the authority in the round and say the reasoning is pithy in Shackle, to say the least. There's no consideration of any relevant authority. There's no consideration of the party submissions. There's in detail. And on this occasion, while some judgments on the issue of admissibility are, of course, formidable pieces of work, respectfully, this is perhaps has not been thought through in the way that one might have hoped that it would have been thought through on that occasion.
It's a strong court.
It is, yes. And my lord, I have to be quite frank. Shackle is a. If my life didn't have Shackle in it, my life would be demonstrably easier. But I'm shackled with Shackle, and there we are.
We were waiting for somebody to say
Can I
that.
withdraw that immediately, my lord? So there we have. But the court's approach was to identify a principle, if indeed it is a principle, which they readily accept was subject to exceptions and was not of universal application. That there exist differences between married and unmarried couples. in particular differences in legal status and legal effects. And referring to Lindsay in the UK, which is a 1986 tax case, they said that marriage continues to be characterised by a corpus of rights and obligations which differentiate it markedly from the situation of a man and a woman who cohabit. Well, that may be a principle, it may just simply be a statement of fact, but if it is to be viewed as a statement of principle, it's a principle with plenty of exceptions. Invariably, this is where, notwithstanding the differences, the situations are relevantly similar. The exceptions tend to be cases where the European Court has glossed over the comparability debate and gone straight to the issue of justification. So we don't, just in approaching the Shackle case, we don't seek to argue that marriage is not characterised by a corpus of rights and obligations that can differentiate it, even markedly, from the situation of a man and a woman who cohabit. But we say that you have to look at this case on its facts. This case involves a widow with children who is bereaved, and her situation, notwithstanding the undoubted differences, is nonetheless relevantly similar to the situation in which a spouse or a civil partner with children would find herself in. Let me just illustrate it with an example. Let us say that Mr. and Mrs. A live at number 2 with their children. Mr. B and Miss C live at number 4 with their children. Mr. A and Mr. B go off to work sharing a car. There's a road traffic accident. Both are killed. Mrs. A and her children in number 2 and Miss C in number 4 with her children are in relevantly similar situations, are they not? This is so despite the undoubted differences that arise from the fact that one couple was married and the other was not. They have both lost the breadwinner. The survivors are left to parent the children by themselves. Both have to try and make ends meet. And certainly as far as the children are concerned, they are in exactly the same situation. And if we take the comparators as being the family unit, then both are clearly in relevantly similar situations. And of course then there are examples, both within an A1P1 and an Article 8 setting, where the courts have taken the view that notwithstanding the differences, the positions of the married and the unmarried are relevantly similar. And there are two particular authorities, if I might open to you. The first is Sahin. Sahin is at volume 6. Tab 54, page 2296. Sorry, 2926. In Sahin, the issue of relevant similarity between married and unmarried persons arose in the context of an Article 8 case, Article 14 when read together with Article 8. And the case was heard and considered by the Grand Chamber in 2003. The issue in this case was the legality of a German law that did not give unmarried fathers an unconditional enforceable right of access to their children.
Surely this case has been reported.
Yes.
Well, we haven't got the reported version.
I'm not sure why that is, my lady. Can I check that over lunchtime, my lady, and come back to you with the reported? I'm not sure that it. Let me check that, my lady. I just don't.
I mean, it's a very, very well-known case.
Exactly. Yes. The issue in this case, of course, was the legality of the German law, as I've said, and the rights of unmarried fathers following the termination of a cohabiting relationship in circumstances where, had he been a married father, he would have had such a right. And the relevant laws are set out at paragraphs 33 and 34 of the judgment, which is at page 2394. Now, in this case, the German government didn't even appear to argue the issue of comparability. They followed the more classic format of simply going to look at the issue of justification. The respondent in its statement of case seeks to distinguish Sahan and indeed PM, which is the next authority to which I'll bring you, by saying at paragraph 44 of its statement of case that there was a direct and unavoidable nexus between adult and child that was entirely independent of the relationship between the adult and the child's other parent. And it was that nexus, as between parent and child, which formed the basis of the rights and obligations in issue. But we respectfully submit that that is not right. The issue in Sahan was Mr. Sahan's right to have access to his child following separation, in the same way that a married man had the right to have personal contact with his child following divorce. And that was in the context of a tripartite relationship, if you like, between the mother and the father and the children. In Sahan's case, he had no entitlement to access other than such was afforded to him by the mother of the child, or alternatively as was determined by the court in the child's interests. Not in the child's best interest, but in the child's interests. And at paragraph 80, the Grand Chamber examined the reasoning of the Chamber on a consideration of the alleged violation of Article 14, taken in conjunction with Article 8. And if I could ask the court then to go to page 2943. So, paragraph 80, my lord, just
80.
Starting from 80, going to 80 and then 86. So, paragraph 80, in that paragraph they recorded that for the Chamber the crucial point was that the courts had not regarded contact between the child and the natural father prima facie as in the child's interest, but it attached decisive weight to the mother's negative attitude and the inevitable tensions between the parents in a situation of conflict. The background. In paragraph 86, the court said, the court started its assessment at paragraph 85, and at 86 it said, as to the situation of divorced fathers of children born in wedlock, in comparison with that of fathers of children born out of wedlock, the court observes that at the outset that at the material time the relevant provisions of the German Civil Code regarding parents not having custody of children born in wedlock and Article 17(1)(1)(2) regarding fathers of children born out of wedlock contained different standards. The former category of parent had a legal right of access which could be restricted or suspended if necessary in the child's interests, whereas the latter's personal contact depended on a favourable decision by the child's mother. At paragraph 87, the court continued, in cases arising from individual applications, it is not, however, the court's task to examine the domestic legislation in the abstract. We said that's particularly important in this case. But it must examine the manner in which that legislation was applied to the applicant in the particular circumstances. The court therefore does not find it necessary to consider whether the former German legislation as such, namely Article 17(1)(1)(2) of the Civil Code, made an unjustifiable distinction between fathers of children born out of wedlock and divorced fathers, such as to be discriminatory within Article 14 of the Convention. The question to be decided by the court is whether the application of A17112 of the Civil Code in the present case led to an unjustified difference in the treatment of the applicant in comparison with the case of a divorced couple. And this resonates with Ms. Manfield's point, which I think she makes much more eloquently than I do in her written submission that it's not the purpose, it's the effect of the provision. And the effect of the provision as it affects the applicant within which this case must be adjudicated. And is that not something that was missing really from the reasoning of the court in Shackle?
Aren't all those three passages you just cited as rather inconsistent with your introduction, which was to suggest that this case doesn't highlight and depend on the existence of a strong nexus with the child? And the case is about access to a child by a father, married or unmarried, one would have thought was not really significant, but German law attached significance to it and imposed a heavy burden of proof on the father of a child born out of wedlock. It all seems to me that that is really saying that perhaps in contradistinction to Shackle, that's the point you have to meet, this case, at any rate, turns on the obvious central fact of the nexus with the child.
Sahan does, yes, certainly. And
yes. I mean, now you were saying it wasn't, it was in the context of a tripartite relationship. That is certainly true in the sense that the German law introduced that tripartite aspect and made mother's consent important, but one would have thought, and the court evidently thought, that that really wasn't what one should be focusing on. What one must focus on is that a child is entitled on the face of it to a relationship with a father, whether the father was married or not, and likewise a father has a legitimate interest,
yes,
whether married or not.
Is this an issue of? I take my lord's point. I'm trying to find the balance and the
I mean, what we've really got to look at, apart from the question whether Shackle is something we should follow, is whether there is, in this particular case, the one before us, a sufficient nexus with the child to
yes,
mean that the sort of reasoning in Sahin has some relevance, but
yes,
the facts are different.
yes, they are. The nexus, of course, we say in the legislation.
Yes, I mean, we've got that point, and
yes, exactly,
that's your strong point. Quite how watertight and logical the nexus is something we'll have to look at a bit closely,
yes,
in the light of the three criteria, which
yes,
you'll get to at some
yes,
stage.
Well, my lord,
Well, there are, of course, intermediate positions that would focus on the link between the deceased and the children. So, saying if these are his children, to whom he had obvious obligations, and clearly, to the extent that the allowance is designed to replace the obligations that he had towards his children and the person looking after them, the survivor, well then that might be one set of
yes,
of circumstances, whereas in fact entitlement goes a little bit wider than that, not a lot wider than that, but it goes a little bit wider than that. So
yes, maybe.
that's another strand to the debate, is it not?
It is. It's not one that I've covered, I have to confess in my statement.
Well, it's
But I can see
all right by you, because
absolutely,
these 4 children are the
absolutely,
children of the couple,
absolutely,
so you're all right.
But to go back, and I can understand the philosophical and logical differences between Sahan and Shackle, but in my respectful submission, the cases are nuanced, and I'm just wondering, with respect, whether nuance is really what's required in the interpretation of these authorities, or whether, in fact, the reality is that Shackle is just wrong, and that we are really trying to avoid the elephant in the room, which is to say that Shackle just was not well reasoned, has not been thought through, and should not be followed.
Nor do we know who was in the minority in Shackle.
No.
This is picking up on my lord's point about
No.
it being a strong
Yes.
chamber,
Yes.
which in respect of at least 2 of its members I would agree with, but
Yes.
first two are obviously
Those are the first two I was thinking of,
powerful
yes.
figures.
Yes, but we don't know whether they were in the majority or the minority,
No, we don't.
or one in each.
So, yes, my lord, I take fully on board Lord Mance's point, but in our respectful submission, fundamentally the reasoning in Shackle should not be followed. What I'm trying to do is highlight through Sahan and PM the difference in approach and difference in emphasis which achieves a different result, which is arguably the proper result. If I might just continue with Sahan. Paragraph 94 then, page 2948. Yes, I've asked you to look at this paragraph within the context not just of the issue, but also in terms of the manifestly without reasonable foundation debate. At paragraph 94, the Grand Chamber noting that very weighty reasons needed to be put forward for a difference in treatment on the grounds of birth, out of or within wedlock, can be regarded as compatible with the Convention. And then they cite the various authority, Mazarek and Barimi. The court then continues, the same is true, and those very weighty reasons, for a difference in the treatment of the father of a child born of a relationship where the parties were living together out of wedlock, as compared with the father of a child born of a marriage-based relationship. So this is a debate to which no doubt we'll come, which is what is the proper test. But the last sentence of paragraph 94, the second last sentence of paragraph 94, I respectfully submit, suggests that the very weighty reasons test finds some support within that sentence applicable to the parents of the children and not just the children.
Well, if what's in issue is something to do with the relationship between father and child.
Yes. Yes. Now, so we say that Sahan has a different approach to what is fundamentally the same problem as was identified in Shackle, and that is the difference between the rights of parents of children born within and outside of wedlock. And Sahan was resolved by looking at the issue of justification, not comparability, which we respectfully say is in accordance with the classic statements within the European authorities. And with respect, we endorse then and support the view taken by Mr. Justice Tracy between paragraph 61 and 68, which is at Core Volume 1, page 62, insofar as he finds comparability for the purposes of the WPA. If I might just ask you to look at what he said.
It'll be 461.
Page 62.
It's the appendix that's your problem.
Does 62 correlate, my lady, with...
No, it doesn't.
Oh, dear.
No. The... Oh dear, my lord has just said the grumbling appendix.
That's even worse than the one I...
It is, isn't it?
Yes.
Yeah. That's true. Yes, but no, the problem is the statement of facts and issues and the parties' written submissions are properly paginated in the hard copy,
Yes.
consistently with the electronic copy, but the appendix appears not to be.
Oh, I'm sorry, Mary. Well, if I might just...
460.
61, comparability is dealt with by Mr. Justice Tracy. It's at my page 62, my lord,
Yes.
of Mr. Justice Tracy.
Well, it is electronically page 62, isn't it, in the court bundle?
Not electronically.
Well,
It's 464.
well, I'm getting it on page 62.
Oh, are you? Oh,
Yeah.
well done.
I don't know.
That's in two places.
It's in two places.
Oh,
Yeah.
well, there we go. No matter. We got it. That's the main thing.
Thank you, my lady. So, if we just look at what Mr. Justice Tracy said, the constant theme of domestic and Convention jurisprudence has been to recognise that generally marriage and civil partnerships are not analogous to cohabitation. In certain circumstances, a cohabitational relationship may be regarded as analogous, and he recites Lord Justice Gervin's summary in Brewster, which was our Court of Appeal judgment before the case came before you. The question whether cohabitational relationships can be regarded as analogous to marriage or civil partnership for the purpose of particular benefits has proved a vexed question. It refers to Serbia. He continues over the page 63. Much will depend on the overall context, including the purpose of the benefit in question. Relationships, whatever their legal makeup, vary widely from couple to couple. The extent to which the relationship can be considered to be comparable for the purposes of imposing some burden or granting some benefit must depend on some relevant facet of the relationships to be compared. The facet that is relevant must depend on the purpose of the burden or benefit to be imposed. Relevant facets, for example, might be whether or not the comparator have children, whether or not the comparator have entered into a public contract, or the duration and stability of the relationships to be compared. In the instant case, the relevant facet is the marital relationship of the applicant. It's not suggested that the substance of the applicant's relationship in terms of stability is analogous to that of a married couple. The question is therefore, does the absence of a public contract, which is the reference to the burden observation, a case made in burden, that the applicant and lay partner make for the relationship sufficiently dissimilar to legitimise different treatment? For the reasons outlined, I now believe that there's a different answer to this question in relation to the two benefits sought. So he refers then to Petrovich, and then he compares and contrasts in paragraph 66 to 68 the differences between bereavement payment, which of course is not a benefit, which is dependent upon the existence of children, and widowed parents' allowance, which is, and he finds that the applicant's claim for bereavement payments failed for reasons that he set out in paragraph 66. And in paragraph 68 he said, by contrast, the facet of the relationship that is relevant to the claimed widowed parents' allowance is the co-raising of children. And therefore, in relation to the comparability of spouses / civil partners and cohabitees under this head, I consider that the relationships are analogous. So, in our respectful submission, Sahan supports us in our contention that Miss McLaughlin should be treated as analogous to her the comparable spouse with children. PM then, if I might, my lords and my ladies, go to PM against the UK, which is again in volume 1 of the authorities, tab 7, page 1177. Is an A1P1 case from the European Chamber. PM lived in a cohabiting relationship with his partner for 10 years, and during their relationship the couple had a child who was a daughter. They separated when the child was 6. PM then undertook to pay weekly maintenance for his daughter, who continued to live with her mother, and the issue was whether he could get tax relief on those payments. So PM argued that he was in an analogous position to married fathers who could get tax relief. And at paragraph 22, which is at page 1181, his argument is set out. He cited the approach taken in Sahan. At paragraph 24, the government's argument was set out. They accepted that the case fell within the ambit of A1P1. However, insofar as the applicant complained that the difference in treatment in this respect flowed from his unmarried status, that he could not claim to be in an analogous position to a married couple. And he cited, the government cited Lindsay, and it also cited, as you will see, Shackle. The government said that the applicant was refused relief solely on the grounds of his unmarried status. The consequence of the couple's free choice not to marry and that there was no differential treatment. It was the relationship of marriage that was at the core of the legislation.
I always wonder when people say the couple's free choice
Yes.
not to marry.
Yes.
Sometimes it is the couple's free choice not to marry,
Well,
but it takes two to marry,
that's right.
so one can veto.
Well, even on the facts of this case, the issue is self-evident that it wasn't Miss McLaughlin's choice. At paragraph 27, so here we have a relationship which is terminated, and we're looking at the Article 8 rights and the issue of what is an analogous position. And the reasoning at paragraph 27 is interesting. The court then looked at this submission. The court acknowledged the submission, but they said in terms that the situations were relevantly similar. They said that PM may claim to be treated differently as an unmarried father than a married father, and though both are parents of the child to be maintained and under obligations to pay maintenance, they said that this was not a situation where the applicant was seeking to compare himself with a couple living within a subsisting marriage, such as in Lindsay. Rather, it was one where the married father had separated or divorced and was living apart from the family, and they said that other persons, not parents, are not covered by the child support provisions and are generally in a situation. They said that PM differed from a married father only as regards the issue of marital status, and may, for the purpose of this application, claim to be in a relevantly similar situation. Now, what this court will note is that the European Court in that case ignored shackle. They don't even address it. Yet, arguably, this was actually a shackle type situation. For in shackle, the comparator marriage was also at an end, albeit for different reasons. But of course, there were children, and there was the quality of the relationship between the child and the parent to take into consideration. And these aspects of the case on PM appear to be determinative. So, again, the court had proper regard to the relationships between the parents of the child, and we say that PM cannot be viewed as a case entirely independent of the relationship as between the parents. So PM is probably a powerful enough authority for the proposition that Strasbourg really does gloss over the comparability test, an observation that, of course, you have recognised in Al Serbia. And I don't propose to open to you your passages between paragraphs 25 and 26 of Al Serbia. Where
You mean I wasn't making it up?
No, but you make some very powerful points, my lady. But when you express as a percentage, I think it was only less than 5% of the authorities, European authorities, dealt with the issue of comparability in terms of stopping the court or inhibiting the court from looking at the justification for the very real differences that exist. So that's Sahan and PM. The next case that I just want to look at very briefly is Burden, Volume 1, Tab 8. The Grand Chamber again had occasion to consider the issue of comparability. This is one of the 4.5% of cases, I suppose. This was in the context not of an unmarried couple, but in a cohabiting sexual relationship, but rather two spinster sisters who had lived together all their lives, and they complained that they were discriminated against, contrary to Article 14, when read with A1P1, in that when the first of them died, the survivor would be required to pay inheritance tax on the dead sister's share of the home, whereas the survivor of a married couple or a civil partnership would be exempt from paying inheritance tax in those same circumstances. The complaint came before the Chamber and thereafter the Grand Chamber. On the issue
did they complain that they couldn't become civil partners, or did they complain that they would be subject to inheritance tax?
That they would be subject to inheritance tax in a manner that was
rather
different.
crucial difference,
yes,
isn't
exactly,
it?
exactly. And on the issue of comparability, the Chamber left open the question whether the applicants could claim to be in an analogous position to a married or civil partnership couple. Could I ask the Court to go to the well-trodden paragraph 62 and 63? Paragraph 62. It is at page 1207. This, of course, is a majority decision. There were dissenting observations. I've set them out in my statement of case, and I don't propose to open them in detail to you. But at paragraph 62 and 63, the majority of the Grand Chamber then examined the differences between the applicants on the one hand and married couples and civil partners on the other. They noted the differences. Paragraph 62 is important because in many ways this is the ratio of the case. They said that the essence of the applicant's relationship was consanguinity, whereas one of the defining characteristics of a marriage or civil partnership is that it is forbidden to close family members. Of course, cohabiting opposite-sex relationships are not forbidden to close family members. The fact that they had chosen to live together all their adult lives did not alter this essential difference between the two types of relationship. So that really was the ratio of that decision. They then go on to deal with the shackle issue at paragraph 63 and that line of authority, noting differences between married and unmarried persons and the cohort of rights and obligations that follows with it. They said that in Shackle, the court found that the situation of married and unmarried heterosexual cohabiting couples were not analogous for the purpose of survivor benefits, and this was because marriage remained an institution which was widely accepted as conferring a particular status on those who entered it. The majority of the Grand Chamber said that it considered that this view still held true, and I have to accept that in the context of this case that last sentence presents some comfort for the respondent, but I would make the following points. Firstly, the observations made at paragraph 63 are strictly speaking obiter. The ratio is found at 62, not 63. Secondly, it was a comment made without detailed discussion or submission on the issue.
There was no reference to children, was there?
No. And thirdly, going back to PM at paragraph 87, sorry, I beg your pardon, Sahan at paragraph 87, the issue can't be determined in the abstract. One has to look at the particular circumstances of a given applicant, in this case the appellant. And although the majority of the Grand Chamber in Burden went quite far, they did not say that there were no circumstances by which cohabiting couples could ever be considered analogous to married or civil partnership couples. The court said that, as with marriage, the Grand Chamber considered that the legal consequences of civil partnership under the 2004 Act, which expressly and deliberately decides to set these types of relationships apart from the other forms of cohabitation. Rather than the length or supportive nature of the relationship, what was determined, they said, was the existence of the public undertaking, carrying with it a body of rights of a contractual nature.
They might have thought, I'm not sure whether it appears, that a contrary decision would undermine the application of inheritance tax in quite a large number of family situations. If you live with your child, would you say, well, that's a situation where we can avoid inheritance tax by having ourselves treated as if we were a married couple?
Yes.
Well, that's why I asked whether the complaint was inheritance tax or whether it was being denied civil partnership.
Yeah.
Because if you want a civil partnership, that brings with it all sorts of rights and obligations and so on.
Yes.
But that's not what they wanted.
No, and that, you're quite right to make that point. The court, in that case, was looking at this issue through the prism of inheritance tax. So,
But it did say that the institution of marriage is one which confers a particular status. Does that not undermine your case? I mean, you can't claim that the relationship between Ms. McLaughlin and her partner is one which carried or conferred a particular status.
no, I can't. I have to acknowledge that there are differences in the corpus of rights and obligations that flow from the fact that they are married. However, my contention is to look to the similarities and the relevant similarities, as opposed to accentuating the differences. And in our respectful submission, where you have a cohabiting couple who decide to have a family, and who live for a lengthy period of time. That, in our respectful submission, and where they are clearly living together at the time of death, that is sufficiently similar, in our respectful submission, to fall within this concept of a public undertaking having been given by these two committed people to each other and to their family unit. And Burden does talk about the existence of a public contract, or a public undertaking, I think is the expression that's used, carrying with it a body of rights of a contractual nature. But it doesn't say carrying with it contractual obligations. It talks of them as being, in other words, there's a mutuality of obligation.
But isn't the public undertaking of which the court is speaking the public act of the registration of a marriage or the registration of a civil partnership, something that is easily ascertainable to the authorities, to the world?
I agree with you that I think that that's what they're thinking about, yes. But whether that can be interpreted so narrowly as to exclude those who have not gone through the ceremony of marriage, but who are otherwise in relatively similar circumstances, I'm not sure that Burden is saying that those persons in all equivalent situations or otherwise equivalent situations are to be excluded. There is a generality in that wording of that paragraph, which I respectfully submit is sufficiently nuanced to allow a situation such as Miss McLaughlin's to fall within.
You do immediately run into the practical aspect that Lord Hodge identified. It's all very well to say that there's an exceptional class, but the border, the boundary, is what appears to have had some influence in the reasoning.
Yes,
the difficulty of identifying it in any particular case.
Well, in the context of a cohabiting couple at the time of death who have children, in my respectful submission, there should not be any real administrative burden. I mean, if we some families, and this family is one, the fact that they were cohabiting was known to the state because they were in receipt of benefits already. The fact that they have children is known because the family is in receipt of child benefit. So to make a determination that this family had, first of all, was cohabiting, and secondly had children, is something that one would have thought, with respect, was sufficiently easily within the knowledge of the state to allow us to meet that particular query. I do accept that when one is in a situation of cohabiting couples who have no children and who have no obvious outward-facing nexus other than their claim that they cohabit or were cohabiting at the time of death, that's when the issue starts to run into problems. But respectfully, in Miss McLaughlin's case, one doesn't have that type of problem.
They seem to regard the conferring of a status as a prerequisite to drawing an analogy, don't they?
Yes, my lord.
And how do you say that a status is conferred by the circumstance that there are cohabiting
well, unmarried is a status, of course, as we know, of itself.
Well, it's a status, of course, but it's not something that's conferred, is it? It's
well, the status.
It's a status for the purpose of Article 14.
Yes.
That's not necessarily for the purpose of drawing an analogy. But it does depend. I mean, your argument is it depends what you're talking about.
Exactly.
If you're talking about inheritance tax, that's one set of considerations. If you're talking about support of children, that's another set of considerations. Yes. That's your point.
Yes, I mean,
rightly or wrongly, that's
yes,
your point.
Well, exactly. If one went to my analogy of Mr. and Mrs. A living next door to Mr. B and Miss C, is their status looking outward any different by virtue of the fact that one is married and one isn't, with their children living in the same household? Of
course, once you allow consanguinity to be an appropriate relationship for the purposes of exempting from inheritance tax, that virtually destroys the tax, doesn't it?
Yes. Yes.
Um,
Yes, yes.
Given that consanguinity is likely to be, in a very large number of cases, the reason for inheritance.
Yes, well, certainly if Burden had succeeded, the consequences were very, very significant indeed. Yes. Time is marching on, my lords and my ladies. I just wanted to very briefly then open Yigit to you. Yigit is the last in the series of cases to which I have referred. It's in our statement of case at paragraphs 145 to 150. It's volume 1, tab 9, page 1211. At paragraph 72, the court set out as part of its consideration, paragraph 72 is at page 1227. The court set out as part of its consideration of general principle that the protection of marriage constitutes in principle an important and legitimate reason which may justify a difference in treatment between married and unmarried couples. So the court essentially repeated what it had said in Lindsay, Shackle and Burden.
Which may justify a difference in treatment.
Yes, yes.
Or which means that they're not analogous situations.
Yes.
Which did it mean? They used the word justify, didn't they?
Yes, it does, it does. Yes. But in our respectful submission within the cohort of European authorities, there has to be an overlap here.
That's the point you've already made, that they skip over
Yes.
the comparability and go straight to justification.
Well, I wish they'd done it in this case, but they didn't.
They start off, yes, they say both things, don't they?
Yes.
As my lady's pointed out.
Yes. But they do use the word may rather than shall in all circumstances. I mean, if one goes to the issue of justification, the fact that one couple is married and the other couple is not should justify, even ignoring if a court decided to ignore the comparability point and simply went to the issue of justification, well, that would be a perfect reason to justify. There is some authority, and I've referred to in my statement of case to Judge Rousakis' observations at page 1237 of the bundle, who delivered a concurring opinion and said that in view of the new social realities which are emerging gradually in today's Europe, manifested in a gradual increase in the number of stable relationships outside marriage, which are replacing the traditional institution of marriage without necessarily undermining the fabric of family life, I wonder whether this court should not begin to reconsider its stance as to the justifiable distinction that it accepts in certain matters between marriage on the one hand and other forms of family life on the other, even when it comes to social security and related benefits. That's 1237. Now, I haven't...
This wasn't a case where there was any suggested nexus, or was there with a child?
No, there were children, but this was one of the cases, it rather resonates with the intervention by the National Children's Bureau, where the benefit was paid directly to the child. And so the issues at consideration ultimately for the court in Yigit related to the mother only.
Only, yes. So it was her interest, and
Yes,
basically
and
they
not
said
the interests of the
marriage
child.
is special, and
Yes.
if you don't get married...
Yes, there was at one stage in the case an issue over one of the children, but that was resolved, and the court's judgment does not impact upon that child. Now, the court has our respectful submission. We haven't laboured the ULA principle point as perhaps as intensely as the respondent has in its statement of case. We rely upon what's said in Manchester City Council in Pinnock. What we do say is that there has been no consistent, clear and ambiguous approach by the European Court of Human Rights to the issue of comparability. And in our respectful submission, what is clear and consistent is that marriage is attracts a different corpus of rights and obligations. But as regards widowed parents' allowance, in our respectful submission, it's not to be regarded as a clear and consistent line of authority. Shackle is 20 years old. Whether or not it would survive the analysis, whether the analysis of 20 years ago would survive today, I respectfully submit that it wouldn't. Insufficient consideration, in fact no consideration really, has been given to the ambit of Article 8 in determining if the measure was discriminatory. An exploration, we say, of that issue would have caused the court to conclude that the introduction of this measure was a recognition by the state of the needs of the surviving family members, and that this was a payment made to assist with the remaining family members as such, to cope with the bereavement process. And as Sir Terence Edgerton said in Smith, bereavement payments are specifically intended to reflect the grief that ordinarily flows from the intimacy, which is usually an inherent part of a relationship between husband and wife and civil partners. And in our respectful submission, Miss McLaughlin and her children fall into exactly the same position.
The Smith case was decided after Mr. Justice Tracy's judgment.
Oh yes, it
this
was.
Case,
yes, I think both Steinfeld and Smith came, in fact, after the Court of Appeal had determined this case.
Yep.
So yes, our Court of Appeal decided the case in 2016. Yeah. So we say, in conclusion of this issue, that our appeal should not be lost at all, but it certainly shouldn't be lost on the comparability point. But that our courts really should require the state, as we prepare to enter the third decade of the 21st century, to justify this obvious difference in treatment beyond the rather simplistic and rigid explanation that one widow was married and the other was not.
Well, as you have said, that marriage obviously does give a status and a corpus of rights and liabilities as between the parties to it.
Yes.
The state's interest is a rather different interest. May have no particular interest in supporting the parties to a marriage, but they may have an interest in supporting children.
In supporting the family, yes.
And
yes.
The obligations of parents towards their children are no different.
Yes, absolutely.
Depending on whether or not they're married.
Well, I totally agree. Ms. Mountfield.
Well, I'm not saying that's necessarily my view, but I think it's the point you're making.
Yes, well, it is, of course, and within the international law context, I think Ms. Mountfield is going to deal with the obligations of the state vis-à-vis its international law obligations, and I'll certainly adopt those. I'll not trample over those submissions, which are much better made by her. But in our respectful submission, looking at the obligations of the state, in our respectful submission, it's very clear that the state has those obligations, and my client is entitled to receive the benefit of those obligations properly discharged. Can I deal then with the fourth question? I see I've only 15 minutes left, and if I just might hurry through the issue of justification. Justification, of course, is there's the four-stage test set out in Bank Millet and the Treasury, whether the objective is sufficiently important to justify the limitation of a fundamental right, whether it's rationally connected to the objective, whether a less intrusive measure could have been used, and whether, having regard to these matters and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. And of course, as in all of these cases, there's overlap between those four considerations. As to the first issue, whether there is a legitimate aim, at paragraph 231 of our statement of case, which is at page 260 of the core volume 1, we accept that the aim of promoting marriage and civil partnership is a legitimate aim within the jurisprudence of the European Court of Human Rights. It's capable of justifying the limitation of a fundamental human right. I can't imagine there's too much debate about that. Secondly, is this measure rationally connected to that aim? We make our observations on this issue at paragraphs 232 to 233 of our statement of case. one can quite understand a rational connection between a tax or a social security measure benefiting those who are married and having the effect of promoting marriage, so that upon marriage you're taxed differently, you may be entitled to different benefits. These are advantages that are immediate or at least accrue during the lifetime of the marriage. Entitlement to widowed parents' allowance arises not upon marriage, but upon the cessation of marriage, upon death. It's not an allowance available to married couples, but only to the surviving spouse of a marriage. It isn't available to all surviving spouses, but only to those spouses of persons who paid the relevant national insurance contributions. So the allowance is payable not for the benefit of the married couple, but for the benefit of the survivor and the children. So if you were asked to read this legislative scheme in the abstract and ask what did you think was the piece, what this piece of legislation was designed to promote, I don't know that anyone would necessarily say it was designed to promote marriage as an institution. Rather, you might say that the aim would be identified as the state's way of making some provision for the surviving members of the family where the breadwinner has died. The clue is perhaps in the title of the benefit. It's Widowed Mother's Allowance or Widowed Parents' Allowance. It isn't just a widow's allowance or a surviving civil partner's allowance. The use of the word mother and parent mean irresistibly that the allowance is paid to the mother or parent in that role, to be used for the benefit of the children as the mother sees fit. So, if the measure is to be rationally connected to the aim of promoting marriage, there must be a point in time, we say, during the couple's relationship when the existence of the allowance has the effect of promoting marriage. So when would that be? Is it prior to marriage? Is it during the marriage? Is there a deterrence aspect to this legislation? Holding Miss McLaughlin up as an example to what might happen to you in the event that you don't get married? Respectfully, it's not obvious. And so in answer to the second question, is there a rational connection? We struggle with that obviously these questions have to be answered by the court, and the court will form its own view, but we don't accept that there's a rational connection between the measure and the concept of promoting marriage.
Have we got in our materials the rationale for introducing widows' benefits when they were first introduced?
No, we don't. And as I was preparing
as you were
case,
speaking, you wondered if somebody was going to ask you that question.
Yes, I thought that was the question that was probably going to come. The answer is no, and there's probably a little bit more work. And if we might, my lady, and I know that my time's nearly up, if we might make do a little bit of research on that point and try and assist the court.
It might be helpful.
Yes, my lady, I take that point fully on board. The third point then is, could a less intrusive measure have been used? And again, we answer that question in paragraphs 234 and 235 of our statement of case. Bearing in mind that this is an Article 14 case, falling within the ambit of Article 8 and Article A1P1, and also bearing in mind that we are examining the effect of the introduction by the state of a positive measure, that is the making available by the state of a benefit to deal with the consequence of bereavement. Perhaps this question needs to be reshaped for the purpose of addressing the issue of the proportionality of the exclusionary effect of the measure. It isn't a question of whether a less intrusive measure could have been used. The question is whether, in implementing the measure, it is necessary in order to achieve the aim of promoting marriage that all married cohabitees in all situations should be excluded, including persons who are in relevantly similar situations to some spouses or civil partners, such as Miss McLaughlin and her young children. And we say that a less intrusive or more inclusive measure could have been used and should have been used. And as a bare minimum, an entitlement to widowed parents' allowance on the part of cohabiting unmarried parents with children is required. The fourth question then is bearing in mind the severity of the consequences In this case, the effect of the exclusion, the importance of the aim, and the extent to which the measure will contribute to that aim, has a fair balance been struck between the rights of the individual and the interests of the community. And we deal with that at paragraphs 236 to 245 of our statement of case. And we say that on this issue, if I might deal with this very briefly and say, it's the appellant's case that the government's claim that a fair balance has been struck between the rights of the individual and the community is manifestly without reasonable foundation. In other words, if we have to meet the test of manifestly without reasonable foundation, we say that it is. We say that there is an alternative test, such as looking for the weighty reasons that justify the exclusion of unmarried widows and their children from the benefit. And if that is the alternative test, then those weighty reasons are also not apparent. In terms of the balance, this is a balancing exercise. We have, on the one hand, we have the exclusion of all unmarried widows and widowers and their children. And on the other hand, we have the justification, the promotion of marriage, and the argument that to process these unmarried people would impose an additional burden upon the social security system. And in this respect, the court will note that there's no other reason advanced. No one is saying, for example, that there's a need to cap cost or that there's a monetary driver behind this exclusionary policy. The respondent in terms says, well, it doesn't really matter that you don't like where we have determined this balance to lie. It's not a subjective test, it's an objective test. And in the realm of social security law, as long as we can show that we've taken into account everything that we should take into account, as long as we can identify the foundation for our decision, then really the only people who can change or alter that should be Parliament and not the courts. It falls within our margin of appreciation, unless we can be shown to have conducted ourselves in the implementation of the measure in a manner that is manifestly without reasonable foundation. And the government will also say that as for your argument that there should be any lesser form of test, such as the identification of very weighty reasons to justify the exclusionary policy, well, that's just wrong. You've tried that argument before in SG and in Brewster, and there hasn't been any meaningful traction with the court. So in order to look at the justification issue, they say that this has a foundation, this policy, this balance has a foundation, and the foundation is the promotion of marriage. And let's look at that. So let's ask the questions. Well, where is the evidence that this measure has resulted in any couple marrying who would otherwise have remained unmarried? Where is the evidence that this measure has resulted in any couple remaining married who would otherwise have separated or divorced? This measure has been in existence for over 25 years. Where is the evidence that the suffering caused to unmarried widows and their children by being excluded from this allowance has caused any other couple to marry? There's no such evidence. Let's look at it from a different angle. Let's say that there is evidence that the measure does promote marriage. Well, where is the evidence that the exclusion of unmarried widows with children, such as my client, diminishes the extent to which the measure promotes marriage? Where's the evidence that the promotion of marriage cannot be achieved without excluding unmarried widows with children? We say there's no such evidence. The second justification is the administrative complexity point. I've already addressed Lord Manson this issue. In our respectful submission, the state will, in most cases, have a record of cohabitation. It can certainly be provided evidentially by reference to a utility bill or passports bearing same addresses or driving licenses, the sort of record that is usually relied upon. The state will have a record of the birth and the ages of the children. The state will have a record of their parents. And so it doesn't seem like a particularly difficult administrative problem. Put another way, there's no comparative evidence produced that other benefits or credits where the issue of cohabitation is relevant creates any insuperable administrative hurdle. And so in terms of looking at the justification for the balance being set as it has been, and acknowledging that there's a wide margin of appreciation, even if it has to be shown that the justification for the measure and the justification for the differences created by the measure is manifestly without reasonable foundation, we say that this test has been met in this case. There is no evidence to support any argument that the institution of marriage is promoted through the measure or the differences created by the measure, and nor is there any tenable evidence that, of difficulties that would be created administratively by extending the measure to include persons such as Miss McLaughlin. In fact, all of the evidence that is available points to a rise in the number of cohabiting couples over a sustained period of time, in keeping with the life of Section 39A1. I have set out in the statement of case, I appreciate I'm coming to the end of my time, I have set out in the statement of case the relevant sections of SG, the comments by Lord Kerr and by you, Lady Hale, in relation to the involvement of children, and of course that centred upon a debate which I know Ms Mountford is going to take up in terms of international obligations with UNCRC and so on. But if I adopt those observations in the context of children, if we look at paragraph 94 of Sahan, if we look at the limitations of the words in some of the European authorities, such as STEC, where the manifestly without reasonable foundation test is articulated, if I might just refer you, I don't need to open it to you directly, but if you take a note, STEC, paragraph 52, volume 1, tab 5, 1156, page 1156, it describes the manifestly without reasonable foundation test. The actual passage reads, a wide margin is usually allowed to the state under the Convention when it comes to general measures of economic and social strategy. Because of their direct knowledge of their society and its needs, the national authorities are, in principle, better placed than the international judge to appreciate what is in the public interest on social or economic grounds, and the court will generally respect the legislature's policy unless it is manifestly without reasonable foundation. So there are a number of qualifying words to that test, and we say that where there is an impact upon children, as clearly happens here, then that is one such case. And in that respect, I would refer to, of course, Lord Kerr's analysis in Brewster on the same issue. So what we say is that whatever the test is that is to be used, whether it's manifestly without reasonable foundation or the very weighty reasons, it obviously is a measure which requires a very close scrutiny, not a cursory scrutiny. And when one scrutinises it properly, in our respectful submission, the justification for the differences between the two positions, the exclusionary effect of the policy or of the legislation, does not stand up. The final question then, if I may to be very briefly finish with this, is the fifth question in the Gaydon test, which is the difference in treatment based on one or more grounds prescribed, whether expressly or by inference in Article 14. We say the answer to this is clearly yes. In Re G, the adoption case, Lord Hoffman said that being unmarried was clearly an other status for the purposes of Article 14. Birth, of course, is a prescribed ground under Article 14, and any prescribed ground normally requires a much greater intensity of review. And in our respectful submission, paragraph 94 of Sahan which I've described as Salah in my note, obviously watching the football, but paragraph 94 of Sahan is of particular resonance. And so we say, my lords and my ladies, for these reasons, the appellant's case is made out, that the measure comes within the ambit of Article 8, as well as Article A1P1, that the appellant's case is analogous to that of widows with qualifying children, that her exclusion is manifestly without reasonable foundation, if that is the appropriate test, and alternatively, if very weighty reasons is the appropriate test, that those weighty reasons have not been made out or presented to the court. And those are our respectful submissions.
Thank you very much indeed.
Thank you.
Thank you. Ms McMahon?
Mr. McMahon?
Ms McMahon? Mountford.
Child Poverty Action Group supports the appellant's case, but it does so through the prism of the rights, or the unequal rights, which are afforded on the respondent's case to Ms McLaughlin and Mr Adams' children. Article 1 of the European Convention on Human Rights says that the high contracting parties shall secure all the other convention rights and freedoms set out in the other articles of the convention to everyone within the state's jurisdiction. And that reflects the core principle of the European Convention, which is, of course, the starting point of all human rights instruments from the Universal Declaration of Human Rights onwards, and which this court has recognised in cases like Cheshire West, that everyone is born free and inherently equal in dignity and rights. This is not something you acquire on majority or citizenship. You are born equal in dignity and rights. And Article 14 of the European Convention of Human Rights is the provision which gives practical effect to that starting point of equal dignity and rights. It embodies the state's obligations to secure convention rights to everyone, and says that the equal enjoyment of other convention rights and freedoms shall be secured without discrimination on grounds of status. So it's a positive obligation on the state to secure that equal enjoyment of other rights. So the core questions for the court in the context of widowed parents' allowance are what other underlying convention rights are the ones that are engaged and which must be secured without discrimination on grounds of status, and whose rights are they? And Child Poverty Action Group's first submission is that the rights which are engaged include, and this is common ground, the rights under Article 1, Protocol 1 for Ms McLaughlin, but they also include the right to respect for family life and the rights of the affected family. You can't see this only as a narrow case which is only about the property rights of a bereaved parent taken in isolation, or the rights the state decides to confer as an instance of marriage. Because when one parent in a couple dies, the surviving parent and the dependent children face new needs as a family. And so we submit that it's important to the shape of the analysis to recognise that the underlying convention right, in relation to which the state must secure equal enjoyment by virtue of Article 14, is not just Ms McLaughlin's property right, but the right to respect and support for the family life of the whole family, Ms McLaughlin and all four of her children. And that's because, as has been well explained, providing widowed parents' allowance is a way in which the state chose to help to meet those needs and to respect the bereaved family's life as a family. It was paid to an eligible parent not only because they were bereaved of a spouse, but because they were bereaved of a co-parent. And the surviving parent's right to that allowance arose only to the extent of and for the duration of the child or children being of dependent age, an age when they're entitled to child benefit. And we say that it was also a criterion that the child had an actual expectation of dependency, and I'll come to that point, but that's in the language of section 39A3. And it's an agreed fact, and we say a significant agreed fact in this case, that the appellant claimed widowed parents' allowance for herself and her children, which I have on the memory stick at 169, which I hope is right from the core bundle. So WPA is a way, or in Strasbourg speak, a modality of protecting the bereaved family when it loses one parent upon whom we say the children had a relationship of dependency. And it's merely an accident of the social security structure and provision which is given in the UK, that a benefit which was designed to reflect the needs which arise from bereavement and loss of dependency upon the deceased parent are claimed and received by the surviving parent. And the National Children's Bureau has shown that it is not the case that in other states where a deceased, an unmarried parent cannot claim a benefit, that there is no child benefit. It's just that the system is different and the child's claim comes through as a different claim. But in the context of a system such as ours, where claims for children's needs go through a parent and are claimed by a parent on behalf of themselves and their dependent children, there is nothing surprising in the submission that the rights of more than one person can arise in relation to one social security claim. And the Betts case, which I won't turn up, but it's at tab 74 of the authorities, paragraph 43, and for your note on the memory stick at 3381, the speech of Lord Brown there shows that there are circumstances where it's just unrealistic to consider the rights to respect for family life of one person in isolation, even when you're looking at one application, in that case one immigration application. Because the whole point of a family is that it's a social construct, and the rights of one member of the family may engage the rights of the whole family unit. And the Court of Appeal recently said, in the case of DA, which you find in the authorities bundle at tab 64, and the relevant passages on the memory stick at 3142, in paragraphs 94 to 98, that the Article 8 rights in play in that case, which was another benefit cap case about housing benefit, embraced those of parents and children, and therefore engaged Article 8, because their interests in a family home were inextricably linked. And although, for reasons of time, I won't go to that passage in paragraphs 94 to 98, it is instructive because it's an analysis of the way that the Court of Appeal considered that question in the SG case, and the way that the Supreme Court, the Court of Appeal, found in DA, found that the Supreme Court in SG simply parked the Article 8 issue and didn't form a conclusion on it. So we submit that the rights which are engaged here are Article 8 rights, but not just Ms McLaughlin's Article 8 rights, but the children's Article 8 rights. And the reason we submit that matters to the analysis is because once those Article 8 rights of the whole family are identified as underlying rights which must be secured without discrimination in order for the state to comply with its obligations are under Article 14, the question which the court is considering is not only whether the state is proportionately justified in treating Ms McLaughlin's access to property rights differently because she and Mr Adams chose not to marry. The question is also whether the state is justified in treating her children's rights to support for the life of the bereaved family differently, simply because their parents were not married, which is a very different question. And that submission informs the correct approach to analogy, which is my next topic, and the correct approach to justification. Because once one considers the ambit of the rights in relation to which the state has a duty to secure equality, then one can consider the proper context for asking whether there are comparators in a relevantly similar situation who do enjoy rights in that context, and with whom, therefore, there's a valid comparison, and with whom, in relation to whom it can be said that the state has failed to secure equal enjoyment of the underlying rights. Now, what may be said in relation to that, as was said, and which, in the context of that case, persuaded the majority in the SG case, is that the mere fact that there is less money in the family intrinsically has an impact on the children, and you can't therefore say that removing a benefit from the parent has a direct enough impact on the children. But here we're talking about a different benefit. We're talking about an allowance specifically given to a widowed parent as a parent. It's in the title. And it is important also in this context to consider that when you're looking at whether there has been a breach of Article 14, an unjustified failure to secure equal enjoyment of the underlying convention rights, what matters is whether the measure we're looking at, widowed parents' allowance, has the purpose or effect of discriminating against children because their parents are not married. It doesn't have to be the object of the measure to distinguish on grounds of that status for Article 14 to be engaged in relation to that status. And I'll come back to that. That's been clarified since the Shackle case by the Grand Chamber decision in a case called DH in the Czech Republic. And it is an important reason why Shackle may at least have been overtaken by later case law. So when one is considering whether the marriage condition for widowed parents' allowance discriminates between those in otherwise analogous or comparable circumstances on grounds of status, the question of relevant similarity or difference between the circumstances of the different groups is an integral part of the exercise for determining whether the differences in treatment between them are justified. And like my learned friend, I rely on what Baroness Hale said about that in the AL Serbia case. The analogous treatment test isn't a discrete hurdle or gateway which has to be crossed before one can persuade the court to consider the justification question at all, and which, if it isn't crossed, means the court won't consider that question. We say that when you look at the criteria for social security benefits claimed by the surviving parent for themselves and their children when a co-parent dies, the rights you're focusing on are the rights of the whole family, and therefore the correct unit of comparison is the surviving family, not just the surviving partner. And a family where one person has died, having been cohabiting with the surviving parent, and a family where one parent has died, having been married to the surviving parent, are, for the reasons which have been explained by the appellant, in an analogous situation in respect for a claim for widowed parents' allowance, because the practical and effective day-to-day situations are sufficiently similar to beg the question of why the state has decided to allow the first set of families a widowed parents' allowance to meet their needs, but to deny the second set of families that allowance. They're sufficiently similar to require the court to decide whether the justification proffered by the state, which is encouraging marriage and an administrative burden, whether that justification is a proportionate one for the apparent failure to secure equal enjoyment of the underlying Article 8 rights of the two sets of families. And I've explained that the reason the family is the correct unit of comparison is that in the UK social security system, benefits intended for the welfare of children are generally claimed by and paid to children, parents for their children, and that's different from other European social security systems. And we say that that explains why Yigit and Turkey is not, on a proper analysis, authority against the appellant. May I ask you please to turn that one up? It's in the core volume of authorities, tab 9, on the memory stick at 1211. What I seek to draw your attention to in the Yigit case is the passage, or the observation at 1213 at the top of the page, and you see it again at the top of 1215, that the applicant's case was a complaint that she could not receive a survivor's pension, unlike the children born of the relationship. So her children could get a survivor's pension. This is much more like the claim in this case, which isn't pursued at this level, to bereavement allowance, but she says, my children can get the pension even though our marriage is a religious one, not a civil one. Why can't I? Widowed parents' allowance, unlike the benefit in Yigit and Turkey, is intended to benefit children. It's only paid to the surviving parent of a child or children who have lost a breadwinner upon whom they had a reasonable expectation of dependency. And if I may ask you to turn up section 39A of the 1992 Act, which is at tab 1 of the bundle. I should say that the version, as often happens with social security benefits, taken from the internet of section 39A in the bundle is not the most up-to-date version. I think you have been given an updated version.
Where?
Copies were handed up just loose this morning.
No, we had something else loose, but not that.
Well, the material.
I was worried that there was a discrepancy between the version
Yes.
in the bundle and what you say in your written
Yes,
case.
there is, and what we say in our case, and what the respondent says in their case is right. The material passage is the same, but there's some of the preliminary words in section 39A3. Yes.
Yes.
front of us.
Yes. Well, I handed a copy up this morning.
There is a supplementary bundle, I think, which should... Sorry, sorry to interject. There was
yeah.
a supplementary bundle this morning. I should have opened that
Like
to
this?
you. Yes, yes, my lord.
Ah.
And I apologise for that. I should have indicated that at the outset.
There we go.
So that is the correct version of section 39A. And may I draw your attention to section 39A3. The benefit applies to a person, well, section 39A1, to a spouse or civil partner, a person whose spouse or civil partner dies and who is not remarried. Then 2, the surviving spouse or civil partner shall be entitled to a widowed parent's allowance determined at a rate in accordance with section 39C below if the deceased spouse or civil partner satisfied the contribution conditions and the surviving spouse or civil partner is entitled to child benefit in respect of a child or qualifying young person. And then some complicated provisions about someone who's pregnant when the spouse dies. And then section 39A3 says that a child or qualifying young person falls within this subsection if the child or qualifying young person is either a son or daughter of the surviving spouse or civil partner, that is, that person's child, or a child in respect of whom the deceased spouse or civil partner was immediately before his or her death entitled to child benefit, or if the surviving spouse or civil partner and the deceased spouse or civil partner were residing together immediately before his or her death, and a child in respect of whom the surviving spouse or civil partner was then entitled to child benefit. So we say that the Court of Appeal was wrong, and this is on the memory stick at 431, paragraph 60, to say that the statutory scheme was not based on a nexus between the deceased and the children, because the children had to be either the natural children of the deceased, a person in respect of whom the deceased was claiming a child benefit, i.e. for whom they were recognised by the state as being responsible, or with whom they were living in the same household as the person who was claiming that benefit and could be expected to be part of the contributions to that household's welfare and so on.
Is there a legal obligation in Northern Irish law for a person living with the parent of another child, of that other person's child, to provide support to that child? Is it a legal entitlement, or is it? Are you just asserting a de facto relationship?
I can't say that there is, and I suspect that if those people separated, if this was a stepchild,
yes,
then they would not have that obligation. But the point is that the legislation sets out three nexuses, and you have to have one of those.
Yes, but
links.
It's the third one that concerns me, because
Yeah.
it is very important to your case in paragraph 20 that there is a nexus of entitlement throughout subsection 3.
Perhaps expectation is a better word than entitlement.
Yes.
Yeah, because I don't want to put it too high.
That's what was concerning me.
Yeah, I think perhaps,
because,
can I amend expectation, entitlement to expectation?
No doubt someone can tell us, I cannot claim to know Northern Irish family law, but whether, certainly in the Scottish legal system in the past, I knew that if you accept someone into the family as a child of the family, that the person so accepting becomes under an obligation to provide support.
Well, in private law, yes, but
Yes.
that depends on marriage.
Yes.
So it's expectation rather than entitlement.
I think that expectation is a fairer word because...
Actually, that's not entirely true, because, sorry, we could look into it,
Yeah.
but it's not wholly true.
Yeah.
Yeah.
So we say that the circumstances of Ms McLaughlin and Ms Adams' children when he died were materially identical to those of a family with the same living arrangements and the same financial needs where the parent had been married. She lost a co-parent whom in practical and effective terms she brought up the family because they were his natural children, and they would have fallen within section 39A, 39(3)A if they had been married. She claimed child benefit on their behalf, and they lived with their father, so they would also have fallen under section 39 AC. And the children lost a father who was no less their father than if they had been born within a marriage. He was as integral a part of their lives. He had made the same contributions to the national insurance system. And the children's parents' marital status was irrelevant to their dependency on him or the losses they suffered upon his death. So to condemn those children to receiving no state support upon their father's death and to suffer financial hardship on top of their emotional loss would, in my submission, be to penalise them for something for which they are not responsible and over which they certainly have no control. We had a debate about whether Ms McLaughlin had any power over her marital status, but the children certainly didn't. And I say that to penalise the children in that way is contrary to the approach that this court has taken in the immigration context, in the Zumbas case, in the speech of Lord Hodge. It's at paragraph 10, and again, I won't turn it up, but it's MS 3534. And that is also contrary to the international law consensus, to which I will return, that rights of bereaved children to bereavement benefits should not turn on their parents' marital status. So I submit that when you look at that question and ask, in this context, in which we are seeking a relevant comparator, who are the comparators, for whom was widowed parents' allowance paid, and in respect of whose interests, it is plain that the appellant, as the newly bereaved head of a family of dependent children, was in a materially similar position to a woman who is like her in all other respects, but married. And it is plain, too, that her children were in a materially similar position, and like all other bereaved children in all other respects, other than the fact that they were born out of wedlock. So then I turn to the question, the linked question of justification. I repeat, in the context of Shackle, that it matters to identify the form of discrimination, the effective form of discrimination, in relation to which the court is considering the justifiability and whose rights, because that's an integral part of what form falls to be justified. And that's why I say that Shackle is wrongly decided to the extent that it said that the discrimination against children was irrelevant, or it's at least been superseded. And then I'll turn to the questions of international law. So I said earlier that the DH case established, which was a case about indirect discrimination against Roma children in their education, that a measure is discriminatory if it has a disproportionate prejudicial effect against members of a group, notwithstanding that it is not specifically aimed at them. And the authority for that is DH paragraph 175, MS 3587. And that's why it matters that the underlying rights which must be secured are Article 8 rights of children. Often courts skip over and say, as is within the ambit of Article 1, Protocol 1, we don't need to think about Article 8 as well. But we really do here, because it affects the whole, the question of what is being balanced in the justification exercise.
Doesn't that mean that you don't really need the nexus in the statute at all? All you would do would be look at the social benefit, and if a surviving spouse didn't receive it because they were unmarried as opposed to married, then you would argue, well, they've got children, and the effect is disproportionate because the children are being penalised by reference to their the unmarried status of the surviving spouse.
Well, perhaps, but then one might say, well, that's true of any financial benefit that goes into a household with children. This is specifically a benefit for someone in their capacity as a parent.
Yeah, but you're accepting the premise of my question, which is,
yeah.
I thought for a moment ago you were advancing a much wider proposition, that all you looked at was the effect of a measure. And if it were the case that all you looked at were the effect of a measure, then any social benefit which was payable to a married survivor and not payable to an unmarried survivor could be said to have a disproportionate effect on children if there were children.
Yes, but if they are children who have an expectation of support from that parent, then it tips the balance. It's a fact, yes, certainly a factor in the balance.
You
so
come
it makes
back
my case
ultimately
stronger.
to
yes.
the purpose of this particular
yes.
statutory
yes.
scheme. Yes.
Yes.
Well, as I put earlier, it's possible, of course, to distinguish between the three categories of qualifying
Yes.
children.
Yes.
Because there's absolutely no doubt, of course, that the deceased had an obligation towards his own children.
Yes.
And those for whom the deceased was claiming child benefit, he was
Well, yeah.
definitely fulfilling some obligation towards them.
Yes.
We'd have to look into the qualifications
Yes.
for getting child benefit. It's the last one, as
Yes.
Lord Hodge has pointed out, that the
Yes.
nexus is the least compelling.
That's true, but the reason I focus on the effect is because the respondent sets out some theoretical examples of children who are living with a step-parent who dies, and the mother, I presume, is claiming the benefit. They're not, and those aren't children born out of wedlock. They may have been born in wedlock with someone else. But the vast majority of these children will be children in this situation. We see the statistics on children who are born to parents who live together as if they're married, but they're not married. And the effect of this is inevitably that the marriage condition has a disproportionately prejudicial effect on the Article 8 rights of the children on grounds of birth status, because more of them will be affected than those born within marriage. And so there's a violation of Article 14 unless that unequal enjoyment of those rights by those children is justified. And we submit that shackle should be given no weight. It's a dot rather than a line of authority, for the reasons that we've set out in paragraph 29 of our written argument. It's a chamber judgment, it's admissibility only, it's not unanimous, no professional representation, but more especially because the approach in that case has now been superseded. It doesn't grapple with the question in the DH case, the Grand Chamber decision from 2008, that clearly identifies that a disproportionately prejudicial effect may create discrimination, notwithstanding that that's not specifically the purpose, that's just not part of the Shackle analysis. It's not part of a line of authority because, for the reasons that my learned friend has given, burden was cited is only a proposition that marriage can confer a special status in comparison with sibling relationships where there's no taking on through being a sibling of any obligation to support someone else. And Yiggett was a case which was only about an individual bereavement allowance because the children had their own benefits. But the most significant change since Shackle is the way that the European Court of Human Rights now considers the impact on the analysis of international law. It's a mandatory principle now that relevant specialist international law must be taken into account in interpreting the European Convention on Human Rights and the practice of other European states, which has been helpfully been set out by the National Children's Bureau. The language used by the Grand Chamber in Demir at 3565 is that the court can and must take those things into account. It's also relevant as a matter of common law statutory construction. And in paragraph 35 of my written case, I've set out familiar authorities for the strong presumption that domestic law will be interpreted compatibly with international law obligations. And unlike in the SG case, this is not a case where there can be any question about the strength of the nexus between the Convention on the Rights of the Child and a benefit intended for widowed parents. Now, the respondent says that this is a case where the court can only displace the primary decision-maker's analysis if it's manifestly without reasonable foundation. There is no direct authority on whether that test applies if one's looking at Article 14 in the benefits context, but where Article 8 is engaged. And I'm not arguing that point today. But I say that even if that test does apply in this context, it is also clear and established law on the basis of what my Lord Mance said in the Government of Wales Act case, which was affirmed by the Supreme Court in A and B and the Secretary of State for Health, paragraph 33, MS 3350, that it is irrelevant to the question of fair balance. The manifestly without reason foundation test is irrelevant to the question of fair balance, which is one for the court to decide for itself. And using the Human Rights Act principles of interpretation through Demir and at common law, it will be a matter for the court to look carefully at the individual balance to ask whether it is fair to incentivise adult behaviour by penalising children who are in a financially very different situation. And we say, in short, that the marriage condition is incompatible with two clear consistent and relevant principles of international law. We've set out the materials upon which we rely in the written case. The first is that children in need shall enjoy the same social protection whether they are born in or out of wedlock. And I've set out the provisions in the case. And the second principle of international law, which is breached by the marriage condition for WPA, is the principle that the best interest of the child shall be a primary consideration in all actions concerning children, and there is simply no evidence that the best interests of child survivors have ever been considered as a primary consideration to be weighted against other considerations in the design of widowed parents' allowance. And in short, whether or not it's the purpose of the marriage condition, it is its effect that bereaved children whose parents are not married are treated as less worthy of respect and protection in the face of their loss than bereaved children of married parents. Their best interests haven't been taken into account. They have been subsumed to the goal of incentivising approved behaviour, that is marriage or civil partnership, among other parents. They are excluded from enjoying a survivor's parent benefit for reasons which are unrelated to their own need, their own conduct, or their own circumstances. And in consequence, they suffer a situation which is none of their making, which they can do nothing about. So Article 14, interpreted compatibly with the UK's obligations in international law, has been breached in these circumstances. And Child Poverty Action Group is very grateful to have been afforded the opportunity to make submissions from a child's perspective. And for the reasons that we've given, we respectfully invite you to allow the appeal.
Thank you very much indeed, Ms Matfield. Timing by both of you, excellent. It is now time for the court to adjourn, but we'll look forward to hearing from you at 2 o'clock.